Hi, everybody. This is Jeff Fowler, President of the Apartment Owners Association, and I want to welcome you today. We're going to cover just filling out the AOA lease agreement. We've talked about changes that have been made. You can go back and catch that live stream. I know we only had a few thousand people watch it, and we have over 20,000 members in the association. So definitely you can go back and watch Attorney Michael Brennan as he kind of covers the changes. Now, today we're going to actually go through just every input that you have to make there. And the feedback that I've gotten is sometimes it's not filled out correctly. Um, whether it's you're not checking that you're exempt from statewide rent control or not putting in something else correctly. So we're going to cover that today. And then we're going to have, if there's time at the end, we'll have some Q&A. I know our speaker today is very thorough. So we'll see where we're at with that. And just a disclaimer, this is not legal advice. It's general in nature as always. But one thing is for sure, we are dedicated to your real estate success. And we know that what you don't know could cost you a fortune. We all know that. And one of the things that you may not know is how good your applicant is. And so we have lots of ways lots of different tools to screen your tenant to verify that they're who they are. And we want to invite you to utilize your AOA membership to the full. Those credit reports, they're $8.50 for the tenant risk by TransUnion, which is one of the most. It's a very updated score and great credit report. I hear from other members, not from other members, from members that what we have in that report is different, and there's a whole lot more information in there just on the credit report alone. But then in addition to that, I want to make sure that you're aware of the civil and criminal investigative reports that we have. And a lot of people are searching criminal. Not everybody's searching on the civil side. So we think that you should see if they're litigious, and that you should see, especially if you're in multifamily, that you should see whether they have a record of domestic violence. And anyway, so those are some just one highlight for you, one thing that I just want to put a spotlight on. And if we get the right people in there, then life is good. So, and it is more like that passive income, slightly more like that when we get the right people in there. So definitely want to invite you to utilize that. And also, I want you to check the AOA PAC website. PAC is Political Action Committee, and we have just a big deal, this AB 2042 that has kind of made its way through the legislature, and we are asking people to call. And we did a live stream about this last week, had a guy, an attorney named John Healy that came on with like 50 years experience. And anyway, he alerted us. He happens to be an AOA member. So definitely you can watch the video, or you can just go straight to the PAC website. It's PAC, PAC dot AOAUSA.com. So AOAUSA.com is the regular one, and then just put PAC on the front of it basically. And it'll get you there, and you'll get all the information that you need for that. And we also do have a voter guide that came out. If you haven't dropped your everything in yet, we do have one, and do have some of the Orange County um, people on that. And so this is mainly for Orange County. We didn't plan very well. We missed Memorial Day and planned to have an event on the day after Memorial Day, which didn't work out too well. So we're doing this one live on the live stream. And I do want to also celebrate with you guys. Oh yeah, so for the voter guide, just type in voter guide on the AOA USA website, AOAUSA.com, type in voter guide, and the voter guide will come up there. And hey, um, you know, everybody's entitled to their opinion. We wanted to put it out there just because we get asked a lot. If you don't vote the way that we do, that's fine. And but we do want you to exercise your right to vote, whether you agree with it or not. But you could take a look at that if you're looking for some people who are going to be more for property rights. And Also, we put out an AOA alert for the city of Orange, and it looks like they are not going to, it looks like they tabled that tax assessment, which is great. And we had a win also with the LA rent gouging. LA County had a rent gouging ban in place, which is ridiculous because rent gouging, aka just raise the rent up to market after someone vacates. So that was ridiculous, but at least it's over. And anyway, so there's a lot of political action stuff going on. And then just your regular life now, you're probably having people move out and move in and everything. And so we hope that this seminar is good for you and meets you at the time when you need it. We will have the Long Beach AOA Million Dollar Trade Show coming up on August 19th. So mark your calendar for that one. And our today's speaker will share a legislative update at that trade show. So we hope that you can make that. And as normal, we have, so many different visitors or vendors that'll be there, and it will be a great day to get together and do that. So without any further ado, I want to get into today's topic, covering that AOA rental agreement specifically for Orange County. Our speaker today has been in the industry for over 25 years, 17 as an attorney, and maybe it's 17 going on 18, not sure. And he's the president and founder of Brennan Law Firm. And so that's kind of the giveaway there. He does landlord tenant litigation and evictions, not just an eviction attorney. And he sits on multiple legislative committees where he reviews and interprets proposed legislation that would affect affect the rental housing industry. So, Michael, it's so great to have you with us today.
Good morning,
And
Jeff.
I'll just turn this over to you. I know you have a presentation and you're gonna work through it all. And thank you so much again for joining.
You're very welcome. Good morning, everybody. It's 19 years going on 20 now.
Oh,
It,
okay. Let
it
me
seems
update
it
that.
seems like just yesterday, but it's actually closing in on 20. I have been in the commercial real estate industry for a little bit more, almost, wow, 30 years now, almost. Um, just to clarify something you said, this is a very thorough overview. It's not simply how to fill out the lease. What I'm going to do is I find that a lot of landlords and certainly management staff, management companies and management staff really don't understand what the lease means, how it protects them, and so or what their obligations are under the lease. So what I'm going to do today is we're going to go through it provision by provision. I'm going to give you like an overview of each provision, then what it really does for you, how it protects you as a landlord, and then I'll give you a practical tip on each one of those. So we have a lot to cover today. Before we get started, like Jeff said, this is not legal advice. The biggest issue that we run into trying to apply a lease to any situation is that in California, but in Southern California specifically, there's quite a few different jurisdictions that have their own either rent control or just cause provisions that are in place. And so what Jeff has done is he's done a fantastic job of putting together a lease that covers the high level situations that can be applicable to virtually any lease. But I will caution you that some of the stuff, and I'll try to bring it up when it's relevant to a slide, but some of the stuff you'll have to look at your local laws, your local rent control, or your local just cause ordinance to see specifically how that will impact what it is I'm talking about. And then before we begin, I just want to say that what's important to understand is these agreements are written contracts, and I know all of you know that. But really, what they do is they establish the parties, both the landlords and the tenants, rights and obligations. What does the landlord have a right to? There's certain things that they have a right to, but also what are the landlord's obligations? And so we'll unpack each of those as we go through. And like I said, I'll try to do a little blurb on why each provision is in there and why it's important. So having said that, let's just jump right in. We already did the disclaimer. We'll talk about some of the agreement basics. So what I'm going to do is I'm going to start with the lease, and hopefully you guys have a copy of the lease available to you or on your computer right now that you can take a look at it. We're going to start on page 1 before we get into the numbered provisions. we'll start right at the top of page number 1. I cannot emphasize this enough. This section has to be filled out correctly, and I'll explain some of the real life problems that I've run into. But it starts with the lessor, owner, or agent's name. So you don't have to put the owner's name on there as the lessor. It can be either the owner or the agent. What I will point out is that there's only two people that can bring an eviction. It's the title holder or the agent. And when I say agent, preferably an agent with a written management agreement that allows that agent to bring an eviction. So I know a lot of landlords don't want the ownership structure known, or they don't want their name known. And so they have a manager, and they have that manager go ahead and fill that out right there. That's fine. But make sure, remember, these things can change, right? You can have a management company. If you're going to put that as the lessor, you can have a management company you're working with today, but in the future that may change. So it might make sense to use the title holder's name, that section right there. And then going below, you'll see tenant, lessee, resident, and you'll see 6 spaces for that. Who should be in that? Obviously, your tenant. Which tenants? Your adult occupants. Okay, this is not a place to put the names of children or minors. The only people you want to put in there are the lessees, which have to be by contract. I mean, by statute, they have to be 18 or above. So you want to list the name of every single adult occupant that's going to be residing in the premises as a lessee. We'll talk about that in a little bit. There's a provision in here that makes every person you list joint and severally liable. So if you've got adult occupants living there, make sure they're listed in those section. And here's
So,
the
hey,
important one.
Mike, are you sharing right now, lease agreement and false application statements? That slide, or are you actually
No,
have?
I apologize for the confusion. That's provision 1. So I'll go back here. What
Okay.
I'm talking about is the section above provision 1 that has the lessor, the tenant, the property address, what the
Right.
monthly
Yeah.
rent is. So I apologize if that was a little confusing. So I'll leave it on slide 1 for right now.
Okay. Yeah. I
Um,
didn't know if you were sharing the lease agreement itself
I'm
or if you
not.
were just talking. Okay. Good. Okay.
Yeah.
Thank you. Okay.
All right. So thank you for the clarification. So what I started to say was the next line is one of the most important lines in the entire lease. It's the unit address. And I can't tell you how many times I've run into problems. It's surprising how many times I've run into problems where either the management company or they fill it out wrong. They put the wrong zip code. They put the wrong unit number, something along those lines. They do not put a unit number in there. Or I've run into situations where there's a mailing address, what we would call the address that would be on the parcel number, the APN. But because maybe the property's on a corner and another street has a more desirable name, the owner will develop an address for that street, like Sunset Boulevard, for example, and they'll use that address. The problem that you run into with that is that when it comes time to do an eviction or a lockout, the sheriff won't conduct the lockout. Any problems in the address at all will cause problems in an eviction and the lockout. So make sure in the unit address you're putting the actual legal address, and you're triple checking it to make sure the unit number is correct, the zip code is correct, and the street address is correct. And try to be legible about that. We've run into issues of legibility before as well. The monthly rental rate is pretty straightforward. What are you charging them for rent? And then the next to the right of that is the agreement shall commence on. That's the day the lease begins. It's not the day they move in. Sometimes landlords will let them move in a day or two early over the weekend, but the lease really takes place, it starts on the 1st. But don't do that. Make sure whenever they're moving in, that's day 1, and that should be accurately reflected in there. It'll tell you the rent due on date. My suggestion to make things simple for everybody is put the rent due on the 1st. There are some exceptions to that. If the tenant or applicant at that time tells you, hey, I'm on Social Security, I get paid on the 15th, then maybe you put the rent on the 17th or 18th. I don't know. That's up to you. Generally, the 1st is the easiest and clearest way to go about that. Security deposit, a lot of the security deposit laws have changed. We'll talk about that more when we get to that provision, but that's where your security deposit goes. Underneath that, to the right of that, I'm sorry, you have either a month-to-month agreement or a fixed term lease. So either a periodic tenancy, month to month, for example, or a specific term. Most people will use 1 year in that. If it is 1 year, if you're going to go on a fixed term, make sure you check the boxes. And I'll say that as a broad statement right now. Look for all the check boxes in your lease. This is a webinar on how to fill out the lease properly. We see a lot of leases come through where nobody checks a box and they just fill in a blank line or something. Make sure you check that box as well. There's something called statutory interpretation or contractual interpretation by courts and judges, and it can impact the outcome of any sort of a case. So month to month versus a 1 year. Personally, if you're in a non-rent control jurisdiction, I like month to month. It allows me a lot of flexibility. If you're in a rent control or a just cause jurisdiction, then my view is I'm stuck with a tenant. I'm locked in. They might as well be locked in as well. I would like to see 1 year leases in rent control or just cause jurisdictions. Then you've got your late charge. It says 6% max. That is according to the California Supreme Court. We'll talk about that in greater detail later. And then parking spaces and storage spaces. If you are a landlord that wants to put them on separate agreements, and I encourage that, you can charge rent for a parking space or a storage space that is separate from the lease agreement, which can be very helpful in a non-rent control jurisdiction. But if you're going to do that, make sure you put N/A, not applicable, in these spaces. And we'll talk more about the parking when we get down to that provision. So we've covered that top box, what I'll call the basic core elements. Now we can jump into the specific provisions. So let's talk about provision number 1. Right? I'm going to summarize it. The agreement evidences all of the terms between the parties. The resident acknowledges in this provision that any false statements in the rental application will constitute a non-curable breach. In other words, did they lie in their application? Did they tell you they have no pets and then all of a sudden they showed up with a pet? And then they've got to provide an updated, another aspect of this provision is that the resident has to provide an updated application upon 7 days written request. I want to clarify what that means and what it doesn't mean. Yes, you're allowed to keep your contact information current, and in fact, you're encouraged to do that. What it does not mean is that you're allowed to screen your tenants over and over every year. It simply says that you have the right to ask them on 7 days written notice to update any contact information, update their car, update who's living there. And that's really the key here is you want to know who's living in that unit. And by having them fill out the application, call it an application, but having them fill out all the personal information again is a great way to do that. Section 1 does 3 things at once. It establishes that the document is the entire agreement. It says that there's no oral promises outside of this written contract that count. I get that all the time. Oh, the landlord told me this was going to happen. Well, it doesn't matter. That's not what's in the lease. Second, and this is critical, a false application, like I said, is a non-curable breach. It allows you to skip past the 3-day cure notice. But that I'm going to caution you on. Be careful in your local rent control or just cause jurisdictions. You may not be, just because the tenant says something false in the application, and depending on when you find out about it, you may not be able to skip right to a notice to quit in that situation. And third, the right to demand an updated application. I just talked about that. That's your best weapon against unauthorized occupants and undisclosed income changes. Keep a copy of every application. If you suspect there's any unauthorized occupants that have moved in, use your Section 1 right to demand an updated application within 7 days and document everything you get in writing. Do it through email or text, whatever you need to do, but make sure it's documented. All right, moving on to Section 2. This talks about payments. Rent is due at the manager's office or another place designated in writing. No cash is accepted. Electronic payments require prior written authorization from the owner and must use owner-specified platforms only. The initial rent and the security deposit are covered here and are due before the agreement commences. The no cash provision protects your managers or your safety. It creates a payment paper trail. The electronic payment restriction is mostly legally significant, is the most legally significant language here. It prevents tenants from unilaterally signing up for Zelle or Airbnb or Venmo or anything like that without any sort of a third-party platform, without your written authorization. And let me just make sure I'm not missing anything. Once you accept electronic payment, if the tenant attempts to pay you without your prior written consent to that and you accept it, you may be establishing a pattern and practice that you can't get away from in the future. So this is a good way to make sure that that doesn't happen. I would say never verbally agree to accept a new payment method. Do it all in writing. Any change in payment platform has to be documented. It should be signed by both parties. Otherwise, like I said, you may be waiving your right to insist on a very specific payment method in the future. And it does cause problems, especially in evictions. If you agree to accept Venmo, for example, and you're in the middle of an eviction, the tenant may pay you through Venmo and ruin your entire case, and you may not even know about it. So be cautious with the platforms you accept. All right, let's talk about some money matters. We're going to move on to provision 3 here. We're talking about late charges and return checks. Late charges of up to 6% of the monthly rent. That's the maximum allowed by the Supreme Court of California. There is a specific case in which the Supreme Court said 6% is a reasonable late fee. The provision has to have specific language to make it legal, but this lease has the language, so I wouldn't worry about that at all. Return check fees. The first return check is $25 for that first occurrence, and then after that it becomes $35, which is right in the statute. It's not something we just made up. If a return check, what I want you to remember is if the tenant bounces a check or gets returned for any reason, and then that causes the rent to be late, which most of the time it will, the late charge will also apply in that situation. So be cautious. Again, this lease has it, but if you have other properties that you've either purchased, inherited, something like that, with late fees provisions in there, make sure you take a look at those. Not all late fees are legal. And California has struck down late fees that are not a reasonable estimate of the actual damages. That 6% cap is set by statute and, like I said, the California Supreme Court. But you want to make sure you understand what you're allowed to accept and how you do it. I want to take a look at it real quick because I know there was a question about it from one of the members before. It says, parties agree that if the resident fails to pay the rent in full by the end of the blank day after the rent is due, they're going to pay a late fee. So what that is designed to do is it's a grace period for the late fee. It does not mean that the tenant has the right to pay rent. Let's say you fill that in with 5 days, which is the standard that I see all the time. That means that they can be late 5 days before the late fee kicks in. It does not mean that they are allowed to pay their rent late by 5 days and it's a grace period on the rent. If they fail to pay the rent when it becomes due, let's say it's on the 1st, on the 2nd, you could turn around and serve a 3-day pay rent or quit. It just means that the late fee wouldn't kick in until that grace period passes. So if you want it to be just 1 day and then there's a late fee, that's fine. Fill it in with the 1. If you want it to be 5 days, fine. Fill it in with the 5. I wouldn't necessarily put a dollar amount there. You can, as long as that dollar amount is less than the 6%. But I would fill in 6%. And when I say I'd fill it in, I would write the word SIX, 6% of the monthly rental obligations. And then finally, there's another blank space in there that says, if the owner elects to accept rent after, again, a blank space, day after is due, payment in a form other than by personal check may be required. Same kind of situation. And I know Jeff and I were just talking about changing this so it's a little easier to understand. But in this lease that I'm looking at, it's a blank space. You can fill that in after 3 days. So in other words, if the owner elects to accept rent after the 3rd day after it was due, you can demand that the rent be paid in a form other than personal check. Whatever you want, you can fill it in. Or you could write N/A, not applicable. It's up to you how you fill that in. Also, since we're on at the beginning of the lease, I'll point out at the bottom of the lease on every page, you'll see the resident's initials, and there are 6 blanks there. Your residents should be initialing every single page. And throughout the lease, I know for the landlord there are some, I believe there's some spaces where they, next to a specific provision that have the ability for the tenant to initial there as well. The purpose of this is to demonstrate that the tenant read every single page and understood it, and that's why they're initialing it. So don't ignore that, the initials across the bottom. The point is to demonstrate, like I said, that they read the pages, they understood that these pages are part of the agreement, and they understood the provisions on those pages. Okay, let's move on to security deposit rules, which is paragraph 4. I'm going to summarize it. The deposit secures the resident's performance, basically. It can't be used as a last month's rent. That's what the provision says. And the owner can withhold unpaid rent, damage beyond ordinary wear and tear, cleaning, missing property, and then the unused portion has to be returned. And that provision lays all of this out. Now, I will remind everybody, over the last 2 years, we've had a significant number of changes to the security deposit law. The amount you can collect has been reduced in most situations down to 1 month's rent. There are some exceptions for very small mom and pop landlords where you can still ask for 2 months' rent, but in most situations, it's going to be 1. And the laws on taking pictures have changed too, if you weren't aware. You've now got to take 3 sets of pictures for the security deposit. Timing, how you can do the deposit, who you send the check to. There's a significant number of changes that have taken place. This is not the proper time to go through them, but if you weren't aware of that, I would encourage you take a look at the most current version of the security deposit law, which is set out in California Civil Code 1950.5. That code governs every aspect of the security deposit. You're not allowed to charge a last month's rent, which is frequently included in older leases, and the tenants can't apply their rent to the last month's rent, or they can't apply their security deposit to the last month's rent. There's quite a bit to it. That's why it's a big provision in your lease. I'd make sure you understand it, thoroughly. There's only 4 permissible categories you can use the security deposit for. They're laid out in that provision. So go through it. Here's a practical tip. Complete a thorough move-in inspection report and have it signed by the tenant on day 1. Now, like I said, remember, the laws just changed. You've got to photograph the unit. And so you might as well do that ahead of time and come to the move-in report with those photographs and have the tenant sign off on the move-in report, as well as the back of the pictures, so you can establish what the condition was like when you actually gave it to the tenant. That's going to be your best protection when the tenant later claims either that, hey, I gave the property back to you better than you gave it to me, or they're disputing any of your deductions. All right, let's move on to utilities and the tenant's responsibility. So I'm on paragraph 5 now, provision 5, summarize it. Tenant pays all utilities unless the landlord fills something in. So if you look at, if you're looking at your lease right now, it literally states, resident shall pay for all utilities and or services based on the occupancy of the premises, except, and I've had clients who have filled that in backwards. They thought that was what the tenant was supposed to pay for, and they filled in what the tenant was supposed to pay for, when in reality, what they just did was they put that burden on themselves. So make sure you understand that that blank space there is for what you as the owner are willing to pay in your utilities. And then there's a checkbox underneath that says the premises do or do not have separate gas or electric meters for the residents dwelling in it. Let me explain what this is for. If your meters are individually metered, or if your building is individually metered, no problem, check that box that says that. But if your property is master metered, then obviously you want to check the other one. The purpose of this provision, the way it's laid out, is in a situation where your building is individually metered, oftentimes one of the units will have something from the common area attached to one of the individual meters. And under California law, I'll give you the code section, it's 1940.9. It specifically states that you have to inform the tenant of that specific tenant. And you guys can come to an agreement, and the language is in there, how you want to handle it. But you can come to an agreement that says, for example, if the common area lights, electricity, are hooked up to unit number 1, you have to disclose that, and you have to allocate, how much of a credit you're going to give the tenant for that, or are you going to give a tenant? You're supposed to legally, but that's all set forth in paragraph 5. And it does come up, and the way it comes up, it hasn't come up a tremendous amount, but I've had a couple of evictions over the years where we were evicting for non-payment of rent, and then the tenant knew in advance, in my opinion, that the common areas were included in their rent, and they came back and used that as a defense to the eviction, successfully used it, because they weren't supposed to be paying that. So they had been overpaying in a small amount, maybe a few dollars every month, but they had been overpaying for years. And it was all because the landlord hadn't disclosed to them and hadn't come to an agreement that, hey, we're going to discount your rent, or we're going to, credit you back X amount every month. They hadn't read the provision and filled it out accurately. So that's what paragraph 5 is about. It's a real affirmative defense, so don't skip over it. All right, paragraph 6, subletting and short-term rentals are a non-curable breach. Summarize the provision: no assignment, subletting, or transfer without the prior written consent of the owner. Advertising the unit by any means, including word of mouth or short-term rental short-term rental websites without that prior written consent is a non-curable breach. And this pops up, as you might imagine, frequently. The tenants start putting the units on Airbnb or Vrbo, and they're actually using the unit. They don't even live there, and they use the unit to make profit. So depending on the jurisdiction, that may be a non-curable breach. You may have to approach it differently depending on where the property is located. But it does state that that same provision states you can't use it as a short-term rental, you can't sublet, and the unit has to be used as a private residence explicitly. If you do discover that a tenant is renting on Airbnb, document it immediately. In fact, what I would tell you is talk to an attorney. Not only can you terminate that tenancy, in certain rent control jurisdictions, we have found that it's beneficial to have the tenant terminate their own tenancy. It doesn't work in every single jurisdiction, but we've had the tenant terminate their own tenancy, and we've done that by stating to them, look, we're going to end this, or we're going to come after you for, it's called disgorgement of profits, for all the profits you've been making. And if we can't get you to agree to that, then we've documented, if you find it out it's going on, that your best move right off the bat is download, or cache, as they would say, cache all of those ads for the short-term rentals, so you can prove that tenant has been illegally subletting it, and you can terminate that tenancy. Don't accept any rent if you know that that's going on. Just tell them, look, we need to resolve this situation first, or we will be terminating your tenancy. Let's see, that's paragraph 6. Paragraph 7, obviously an important provision, not only here. It says occupants staying over 10 days cumulatively, or longer during any 6-month period without the owner's written consent shall be considered a breach of agreement. So again, here's one of those provisions where I state, be careful with your jurisdiction. You have to know the laws that apply to your jurisdiction. For example, there's one county in particular I'm thinking of right now that specifically states you cannot evict people for unauthorized occupants under any circumstance. So, you have to know your local laws. But assuming this is just, let's say it's a single family house, not subject to Tenant Protection Act, this basically says, hey, if you have a guest who stays more than 10 days in a 6-month period, we're exercising our right to declare that a breach. And the purpose of that is basically to prevent in advance unauthorized occupancy, because it happens quite a bit. People start showing up as a guest, and then all of a sudden you have this unauthorized occupant in your unit. The provision also gives you the right to raise the rent by either $100 or 25% of the current rent, whichever is permissible. Each jurisdiction may have a different amount. Even in your most strict jurisdictions, typically they will have something in the ordinance that'll say, as long as it's in the lease, an additional occupant allows the landlord to charge X amount of dollars. Okay, let's see, paragraph 8, I believe we're on. Yep, paragraph 8. Summarize it: no animals without prior written consent, which is revocable on 30 days written notice. So be clear here. I think most of you already know this. There's a difference between animals and pets. There are certain things you can do with pets that you cannot do with, for example, an emotional support animal or a service animal. Pets you can charge rent for. Pets you can increase the security deposit on. ESAs, service animals, you cannot do that with. So be really careful. Anytime a tenant shows up with an unauthorized animal, your first step is to inquire about it. Don't just launch missiles at them. Obviously, in most situations, the tenant's going to come back and say, oh, it's a service animal. And there's a very specific process to deal with that. I happen to be dealing with it right now. We've dealt with it, I don't know, thousands of times over the 20 years I've been practicing. But there's a very specific process to deal with that that will keep you out of trouble from or a claim of discrimination based on disability. And it will allow you to navigate the whole process while putting some controls on that process. For example, if they do verify they're disabled, then you're not allowed to charge pet rent. As I said, you can't increase the deposit, but you are allowed to use an animal addendum. And that animal addendum will set out some guidelines on that animal being on the property. For example, it can't be a nuisance, it can't bark all day, it can't defecate around the property, can't urinate on the property. Essentially, if those things are happening, it allows you to tell the tenant, hey, you need to get rid of that animal or prevent the behavior like the defecation on the property, or we're going to terminate the tenancy. And even if it's a ESA or a service animal, that will insulate you and will protect you from a lawsuit. I mean, they can still sue you, but it'll protect you from them being successful in the lawsuit. Okay, moving on to paragraph 9, parking and storage. Again, I encourage, if you're going to provide parking, at least, or storage, think about doing it on a completely separate agreement. And that separate agreement can say, this is a separate parking agreement, it's completely separate from the lease with the exception of the same requirements, or you can just copy the requirements out of here. But basically, if you don't want to do it on a separate agreement and you want to provide the parking, like I said, up at the top, if your spaces are numbered, make sure you fill that in. But to summarize this provision, says parking spaces are for passenger vehicles, approved vehicles only. You can't wash it, you can't repair it, you can't paint it. Owner controls all the parking spaces and storage locations. And importantly, this provision allows a landlord to change the parking spaces on 15 days notice. So why is that important? Why does that pop up? Because you could have a tenant whose parking space happens to be the furthest space from their unit. And they can come back and say, hey, by the way, I was in a car accident. I'm now permanently disabled. I'm asking for a reasonable accommodation. I need you to switch my parking space to one of the ones closest to my door. And you as the landlord may have no parking available for them at that time near their door. This provision would specifically allow you to make that change and tell somebody who's parking closer, hey, I need the space. I have to move you out to this one. This person's disabled. You can't tell them they're disabled. But this provision allows you to move people around in your parking lot without their ability to say no to it. Document all your parking assignments. I would encourage it. If you do offer parking, number them and document them. Keep it in writing, keep a log. If you need to change spaces, issue the 15-day notice and document it. A tenant who refuses to comply after the proper notice is in breach of the contract. What can you do? Is that the kind of breach you're going to evict over? Possibly. If it involves a disability, that might work. More importantly, what you want to do is talk to a local towing company and have the correct signs up on your property. There's specific language that needs to be in your towing signs. And if that's up there, it would give you the right to tow them out of the space they're not supposed to be in. All right, number 10 is kind of a new thing over the last few years. Micro mobility devices, e-bikes, e-scooters, fire safety. I'll summarize it by saying this provision sets the borders to the relationship. It allows one personal micro mobility device per occupant to be in the unit, but they have to comply with certain standards, UL standards. What does that mean? Well, as many people know, and you can look all over YouTube, Google it, these lithium ion batteries can just ignite. They can explode. They can create fires, and it's happened many times. So this states that the device, I'll call it an e-scooter or e-bike, has to be in compliance with that. So do the batteries, so does the charging equipment. It's basically a brand new law it went into effect in 2024. If you want the code section, it's 1940.41. And you're not allowed to ban them outright, but you can enforce these safety standards. So like I said, the fire risk is real. Make sure you have the ability to control it. Now I can say that and I can put it in the lease, but it's difficult to really do that. How are you going to do that? Are you going to really look at the UL numbers on the batteries or the UL numbers on the scooter? Possibly. anyway, it's in there for your safety if you need it. I would suggest you post clear notices around the property. If you've got some common area, put it in there about the micro mobility devices. If you discover that a tenant is charging a non-certified e-bike in their unit, issue a written warning notice immediately. A second violation would give you the right to call it a non-curable breach and terminate the tenancy based on that. All right, let's jump to 11, noise and activity. All right, we're what I call the conduct and maintenance section. Summarizing this, no noise, disruptive activity, nuisance, or waste on the premises, no illegal drugs, no use, storage, or manufacture or sale of drugs. Violation is a breach of the agreement, and in some cases, it'll allow you to terminate the agreement immediately. Basically, this is you regulating their conduct in favor of your building, the safety of your building, the safety of the neighboring tenants in the property, and the safety of the neighborhood. In many instances, if they're violating this, you're going to start with the cure covenants. In some instances, let's say it's nuisance behavior, they're throwing parties all the time. I would suggest you start off with a warning letter rather than a cure covenant. The judges like to see warning letters about this. If it is illegal activity, and I'm somewhat shocked sometimes at how many evictions we've done based on illegal activity, child molestation, assault and battery, something along those lines, you can terminate that tenancy on a 3-day quit immediately. When a noise or a nuisance complaint comes in, I recommend you respond in writing to it immediately. Now, anytime I say today, respond in writing, I want to caution you guys about doing that. There's a couple things to think about when you do things in writing. One, if you're going to respond in writing, write it as if you know for a fact a judge is going to see it. Okay? Don't put any emotion into it. Just be very factual about it. Hey, we got a complaint. This is what's going on. We need to talk about it. This is your warning. If these allegations are true, it's unacceptable behavior. Please look at paragraph 11 of your lease, etc. Document it. Now, be careful what you write. Like I said, write it as if a judge is going to see it, because very likely they are. Sometimes more is less. You don't want to go into more information than you need to, because sometimes you can accidentally say something that can be misinterpreted by what we call the trier of fact or a judge. And you don't want to be standing there saying, that's not what I meant. All right. So be careful what you write. Like I said, keep all of the emotion out of it. Be very factual, logical about the whole thing. But when you have complaints, document it in writing so that everybody's clear about what's going on and what provisions need to be followed. All right, I won't spend too much time on loitering in the common area. Did I skip something? Hang on a second. No, I did not. That's paragraph 12. I won't spend too much time about this. There's a reason to this. For example, one, it interferes with the neighboring tenants' quiet enjoyment of their own properties. But two, it also, people just hanging out in the common area. One, this is you controlling the common area. The tenants do not lease the common area. They lease their apartment. They do not have the right to just hang out with non-residents in your building. And this is one step in that direction. And the point of this is not just to say, hey, you're violating the quiet enjoyment of the neighboring tenants. The point of this is to prevent, partially anyway, is to prevent their guests, their short-term guests, from showing up and just hanging out and becoming, everybody on the property becoming acclimated to them. And then all of a sudden you find out they're not a guest, they're an unauthorized occupant. So that's really what this provision is geared for, protecting the quiet enjoyment of the other tenants, and at least another step in preventing guests from becoming unauthorized occupants in your units. Okay, appliances, important provision. Summarize it. Owner has to provide a stove under state law. Refrigerator may be provided by the owner or by mutual agreement. So you're not allowed to contract around the stove. Again, brand new law. We just worked on this provision and inserted it into the agreement. You're not allowed to contract around the stove. You have to provide the stove, and it's got to be able to heat food to a point that's safe. The refrigerator, though, on the other hand, you are allowed to contract around, and that is in here. If you look at this, number 2, it says a refrigerator, but it's got 2 check boxes there, and it says, hey, that whether the landlord, if the landlord is providing it, whether it's the refrigerator or the stove, we tried to set out some guidelines on that to make sure that the tenant is maintaining it in a responsible manner, in a clean and sanitary manner for both the refrigerator and the stove. But we also gave a box that says, hey, if the tenant's already got their own refrigerator and they want to, provide that themselves, then they have to acknowledge that by checking this box. And this is not an option. This is by law. It's in the statute that this language has to be in there. So it does say that the refrigerator is not provided by the owner. Tenant still has to maintain it. But the key to remember on that refrigerator is at any time, the tenant can change their mind and opt out and say, hey, I want you to provide the refrigerator now. And so if that happens, now you are legally obligated to provide that refrigerator. We still tried to protect you in that by going through the language in this. And then on the next page, you'll notice there's a box that says it's exempt. We're exempt. This property is exempt from the requirements to provide a stove or a refrigerator. And then it gives you the situations under which the exemption would apply. Make sure you read those exemptions carefully. And if you don't know what the codes mean, I encourage you to Google them and look them up and understand it. You don't want to check a box that says you're exempt only to find out later that you're not exempt. And the tenant can now raise that as a habitability defense in some sort of an eviction, such as a non-payment of rent case. All right, paragraph 14. What the purpose of this is to basically allow the landlord to control the property. If the premises are totally or partially destroyed, in such a way that the resident's use is seriously impaired, either party can terminate on a 3-day written notice. Now, again, word of caution, depending on your jurisdiction, that may not apply. Some jurisdictions will say, hey, no, you have to put the tenant up in do what's called a tenant habitability plan, for example. Put the tenant up in similar accommodations until you've fixed the unit. And there's more to that provision. The rent would be abated if the tenant can't occupy the property. If the damage is caused by the resident, in that situation, only the owner would be able to terminate, and there wouldn't be a rent abatement for the balance of the lease on that. So again, the purpose of this provision is to basically allow, where it's applicable, where it can be done, allow the landlord or the tenant to terminate the tenancy if the property becomes destroyed. Most of the times you're going to hear that under some sort of a calamity, like a fire or some sort of an act of God. All right, 15, important provision, condition of the premises. This is where the tenant acknowledges that you gave them the unit in a clean and good condition at move-in. All right, and this is where your move-in sheet becomes really important. You use these two in conjunction. If there's any problems, the tenant is supposed to notify you of that on the move-in sheet, which 99% of the time they really don't do that, or maybe 90% of the time. This provision also states the tenant's responsible for all damage beyond ordinary wear and tear. And at termination, all of the items have to be returned in a clean, good condition. And it sets out specifically that dirt, holes, tears, burns, and stains are not ordinary wear and tear. So providing an explicit definition of what does not constitute ordinary wear and tear is powerful. Courts historically have allowed tenants to characterize significant damage as wear and tear and avoid deductions to their security deposit. And this is an attempt to not get around it, that's a poor choice of words, to enforce what actually constitutes damage. So this provision puts the tenant on written notice that these types of things like burns, holes in the wall, they're not wear and tear, regardless of how long they've lived there. And then when you do your accounting under 1950.5, you want to itemize all of that stuff. And I would suggest you refer back to this provision pursuant to paragraph 15. This constitutes damage. And like I said, use your move-in sheet with your photographs to establish those conditions weren't there when they moved in. All right, moving on. Paragraph 16, also an important condition, talks about maintenance alterations and a tenant's duty to notify the landlord. Very important provision. No painting, you can't change the locks, no antennas, can't put adhesives on the walls. Any alterations whatsoever require a landlord's prior written consent, and the tenant has to get rid of the trash in a clean and sanitary manner. Most importantly, the tenant has to notify the owner in writing of any needed repairs. And if they fail to do that, they're the ones who are liable for any damages that result. So this happens all the time. There's a leak in the kitchen. Tenant fails to notify you of that, and that leak ends up destroying the cabinetry underneath the sink. This provision specifically allows you to charge the tenant for any damages that result from their failure to notify you in writing. And like I said, it happens quite a bit. So it's a very powerful provision. I know in LA, a lot of landlords doubt that they can actually get away with that, but you can. And I'm not going to get into how there is a method of turning any money they owe you into rent under certain circumstances. This is not the time for that conversation or how to do that. But even if you don't go down that path, what you can do is you could file a small claims act. Let's say you have to gut the cabinetry in the kitchen because they didn't tell you about a leak under the sink or in the bathroom. This would allow you to go to small claims court and ask them to reimburse you for all of that money. And like I said, there's a couple, if that happens and you want to know how you can do it without actually going to small claims court, how you can possibly turn it into rent, how you can get rid of the tenant based on that. Give my office a call. I'm happy to talk to you about that. I don't want to discuss it in this kind of a webinar because I know this will be made public on YouTube. And I don't want to explain our strategies to the tenants' rights advocates that I know watch these things. All right, paragraph 17, also important. No smoking of any substance whatsoever. No cigarettes, e-cigarettes, cigars, marijuana, pipes, vapes, etc. It doesn't matter. You can't do it in the property or on the property. And this comes right out of the California Health and Safety Code. It authorizes a landlord to prohibit smoking both indoor and outdoor on the property. The explicit listing of marijuana is important because under Prop 64, as most people know, California decriminalized marijuana. And you'll hear this come up quite a bit. Oh, I'm disabled or it's recreational. It doesn't matter. You're not allowed to smoke anything on the property. And there's plenty of ways to ingest marijuana. Even if you're disabled, you can ingest marijuana without smoking it. And the problem is that the tenants always end up, living right next door to the tenant that's got 2 kids with asthma. So this provision allows you to terminate the tenancy based on that. What I would say is if you discover any sort of smoking violations, document them immediately with pictures, if you can, of them smoking on the property, odor complaints from other tenants, written notices to the offending tenant. Hey, I'm getting complaints that you guys are smoking on the property. I don't care if it's cigarettes, vapes, marijuana. It doesn't matter. I'm getting complaints about it. Look at paragraph 17 in your lease. This is the only warning I'm going to give you. Next time I'm giving you a cure covenants notice. All right, paragraph 18. Smoke carbon monoxide detectors, testing and interference. Basically, this provision sets forth your ability to get in and test the units, and it sets out that the resident acknowledges that the devices were functioning when they were installed. A lot of times you have tenants who intentionally take the batteries out. That this is a way to kind of enforce that, say, no, you can't take the batteries out, and I have the right to come in and check them. Again, specifically set out in the Health and Safety Code, requires smoke detectors in your rental units. It sets a duty to maintain them with working batteries. You can put it on the tenant to maintain the batteries, but the duty to install functional devices is on the landlord, and the duty to inspect them is also on the landlord. Like I said, the most common scenario that pops up is a tenant disables it. When they do disable it, think about this for a second. They're not just endangering themselves. They're endangering themselves, of course, but they're also endangering the property. And if there's neighboring tenants, they're endangering the neighboring tenants, and they're endangering the neighborhood by disabling these things. So that's what this provision is designed to protect you against. I would document your installation of working detectors with pictures. And have a written acknowledgement from the tenant that, yeah, you tested them in front of them. That'll protect you in the event there is some sort of a fire or a problem, or even some sort of a personal injury lawsuit against you. All right, number 19 is house, pool, and laundry rules is incorporated by reference. Resident basically has to comply with all your house rules, we'll call them for right now, and the laundry rules. Anything attached to the agreement. Remember, there was a clause we talked about before that said this is the entire agreement. So make sure that these get attached. They don't have the exact same, if it's just rules, they don't have the exact same weight as a provision, a specific provision, but they're pretty close. These can be changed from time to time, just like you would any other provision. But the word of caution I have on changing these and changing other provisions in your lease is be careful. Again, you have to know what jurisdiction you're in. There are some jurisdictions, I can think of a couple off the top of my head right now, that specifically say if a landlord changes a provision unilaterally, in other words, the tenant doesn't sign off on it, you're just making the change, then that provision can't be used to evict the tenant in the future. One jurisdiction I'm thinking of right now specifically says those changes don't even go into effect unless the tenant signs off on them. So be careful with that. Know what your jurisdiction allows and what it doesn't allow. But in essence, again, these rules have virtually the same weight as every other provision. If you're going to use them, and I know a lot of members and clients that use them all the time, they're great. Make sure that they are attached and the tenant signs off on them as well. I wouldn't hand these out as a separate document. I would, like I said, attach them. You could even do them as an addendum or an exhibit. Always include them as a signed document to the lease. And when you update the rules, make sure you're using a 30-day change in terms of tenancy, especially, well, in any jurisdiction, make sure you do it correctly by using a 30-day change in terms of tenancy. All right, let's talk about the lease life cycle and the owner's rights. We're on provision 20 now, change of terms. We were just alluding to that. Once the initial lease term, let's say you do a 1-year lease, once that expires, you're on a month-to-month tenancy. Now you can change the terms of the tenancy using, in most cases, a 30-day written notice. All changes have to comply with any applicable law at the time that notice is given, and we specifically said that. Some jurisdictions, like I said, they prohibit these unilateral changes and require the tenant to sign off on them. Know if your property is located in one of those jurisdictions. Other jurisdictions permit them to go into place, but prevent you from evicting them unless the tenant signs off on it, so be careful. I would caution you, I still see this happening, even though this law changed about 3 or 4 years ago now. If you're doing one change in tenancy that happens every year is an increase in rent. And for those properties that are not subject to rent control, be careful when you change your rent. If you're going to go above 10%, 10.1%, 10.5%, whatever that percentage is, if it's greater than 10%, it's not a 60-day notice anymore. It's a 90-day notice. And I still see landlords who do it on a 60-day notice. They don't understand that change in the law that took place about 3 or 4 years ago, between 3 and 5 years ago. And they are surprised when they go to do an eviction and they find out that 60-day notice should have been a 90-day notice. And so every increase that has taken place since they did that has been illegal because that notice was illegal. And they actually end up owing the tenant a credit. And so oftentimes their 3-day pay or quit will be overstated as a result of that, and they can't proceed with the eviction. So again, just to summarize that, anything above 10% has to be in a 90-day notice to the tenant. Be careful. Some of the rent control jurisdictions might even require a longer period of time, depends on your circumstances. All right, let's see. Next paragraph is paragraph 21, temporary relocation. This paragraph is specifically designed to, I don't want to use the word force, but that's basically what it's doing. It's basically saying to your tenant, look, we've got something in the unit that needs to be done. You have to temporarily relocate to a different unit for any sort of fumigation, repairs, or hazardous material removals, and they have to comply with all the preparation instructions. In those situations, oftentimes you go basically, and this provision lays this out, what is your obligation to the tenant? Unless you're in a rent control jurisdiction that modifies this, generally what California law says is if they have to move out and the unit's not usable, it's not habitable, as we would say, then you abate their rent. I don't encourage you. I know a lot of my clients will say, well, can I charge them rent for the other unit I put them in? I don't encourage doing that because by doing that, you're going to establish a tenancy in that other unit. And I've had to evict multiple tenants where they put the temporary unit they went into was nicer than their unit, and then they refuse to leave. And they won't give up their other unit either. What do you think they're going to do with it? They're going to put somebody in there and charge them rent. But my point is, be careful if you have a vacant unit and you want them to temporarily vacate, make sure that's documented. Don't take rent for it. Abate their rent on the unit that they're supposed to be in and that you're rehabbing or repairing, but don't take any rent for the new unit. Now, this comes up quite a bit. You might have a rainstorm and the ceiling falls in and you go to repair it and you find out, hey, guess what? There's asbestos in it or there's some other hazardous material. And then all of a sudden, The tenants are refusing to cooperate. They refuse to allow you in to make the repairs. That's another purpose of this provision, is to allow you in to make those repairs. And we've evicted plenty of tenants who refuse to allow you in to make the repairs. And so in our position, and we've been successful on this, I can't think of a case we weren't successful in it. We deem that refusal to be maintaining a nuisance on the property, because they're preventing you from removing something hazardous. And so we've gone ahead and terminated the tenancy based on that. So be careful, be cautious, understand what this provision is about, know how to use it, and it can be used effectively. And then finally, in this provision, which I think is really important because it pops up all the time, is the tenant says, "Oh, I'm not going to move my furniture. You have to do it." Well, that's not what this provision says. That's not what the lease says. This lease says the tenant has to move their furniture and incur any costs associated with moving the furniture. So again, a very practical provision for the lease. All right, paragraph 22, termination. All right. After the initial lease term expires, the agreement auto renews. Be careful. Understand what that means. It automatically goes month to month. Either party can terminate it on a written notice at either a 30-day or a 60-day. This provision also allows you to terminate for one of your family members if you're the owner, you or your family member to move in. Key, important provision. This owner of family move-in is specifically added to the lease to comply with AB 1482. You have to have that language in there to move in yourself, to terminate a tenancy for an owner occupancy or a family member. And what I want to point out to you, what a lot of landlords don't understand in this is there is a good faith component to this, the owner occupancy termination, that's implied in virtually every single just cause jurisdiction. Under AB 1482, the owner or the family member has to move in within 90 days and they have to live there for 1 year, a minimum. After that, they can move out and you can re-rent the apartment. But be careful, depending on what jurisdiction you're in, there are other prohibitions or stricter limitations. For example, you might have to move in 60 days. You might have to be a natural person. Otherwise, this provision won't work for you as a reservation of rights. So the point is, know your jurisdiction, but what this is designed to do is to say, hey, we get to terminate the tenancy, and we're including termination of tenancy for an owner occupancy in here, to move in. Let me see. I think I just skipped one. That was 22. 23 is possession. Yeah, I skipped it. This is a great provision, and it's happened to several of my clients. The owner can't deliver possession on an agreed date. For whatever reason, there was a fire, the rainstorm knocked out the ceiling, the prior tenant failed to move out, and this basically is a get out of jail free card for the owner. If you cannot deliver it, you can cancel the agreement and give the money back, and it allows you to do that. Otherwise, if this weren't in there and you couldn't put the new tenant in there, you could be sued for a breach of contract. So that's what it's for. Paragraph 24, insurance liability, also another important provision. Owner's insurance does not cover the resident's personal property. It's important that the tenants understand that. Resident agrees to obtain their own renter's insurance, and a failure to maintain a policy is a complete waiver of the resident's right to come after you for any damage or any losses to their personal property. And it happens frequently. And I have tenants claim that all the time. Oh, you had a water pipe break in the parking lot and it went through my sunroof that I left open. Now you're responsible for it. No, you're not. This requires the tenant to carry their own renter's insurance. And it does say that they have to add you as an additionally insured, or sometimes the insurance companies would call you an additional interest on their policy. The benefit to that is oftentimes if that policy lapses when you're listed as an additionally insured, you will get notice of the lapse of that policy. So that's the point, is again, protecting the landlords from claims that something went wrong and the loss is incurred by the tenant to any of their personal property is now the landlord's responsibility.
Hey, Mike, I had a funny one with that. We got a notice from an insurance company that the tenant's insurance had expired, but it wasn't for any of our properties. It was for an AOA member, and they didn't make it clear that they needed to put their name on there. It was AOA's our business name was on there as the additional insured.
Oh,
Yeah.
that's funny.
Yeah, I'm like, what is this? Where are we
So,
getting this from?
so as a real life example to clarify that, yeah, make sure it's the entity that owns the property. If it's owned by a trust, put the trust name. If it's owned by, an LLC, make sure the tenant puts the LLC. And you do have the right to get a copy of it. So double check it. Don't just throw it in your file and forget about it. All right, let's see. Paragraph 24, we just talked about that. 25, right of entry, huge. Probably one of the most important notices, provisions in your lease. Basically, what this allows you to do is it says, hey, look, we have a right to enter your property. The owner can enter immediately in emergencies or suspected abandonment. When there's non-emergencies, of course, you have to give it 24 hours advance written notice. But this basically said, hey, we have the right to come in and you're going to let us in. And again, it kind of walks hand in hand with those hazardous materials, or where you have I'm involved in a case right now where the tenant has been complaining, I need roach treatment. I need pest control. But the tenant won't let us in to make the repairs, won't let my client in to make the repairs. And so, of course, there's the right of entry notice in there, provision in there. And now we're terminating her tenancy. We tried to work with her multiple times, saying, look, you're not letting us in. You're preventing us from fixing any problem that really might exist in there. We need to come in. If you don't come in, we gave her multiple warnings saying, if you don't let us in, we're going to be terminating your tenancy. And she just refuses to let us in. And so we're in the middle of an eviction right now because of that. Think about it this way. It's not that their unit, we're not just worried about their unit, right? If there's some sort of a roach infestation that needs to be addressed, it needs to be addressed because that problem is going to spread to every other unit in your building eventually. So it's really a health and safety issue for your other tenants in the building as well. And we do, again, like I said, we do have evictions based on this all the time. You can't, especially in rent control jurisdictions, that's one of the first things that the tenants' rights attorneys tell the tenants is, oh, you're being evicted, don't let your landlord in. Or, oh, you're late on your rent, don't let your landlord in. We'll raise habitability. Well, you have the right to go in there. I do want to point out that emails and text messages for getting in, they don't count. It's very limited where a 24-hour notice can be done through email or text. If the tenant replies, yes, come on in tomorrow, then they've just given you permission, no problem. But if they're vague about it and it's not very clear in the email and text, as I have a lot of clients that do this, they'll text the tenant, hey, you notified us about this. I got the plumber lined up for next Tuesday. We're going to be coming in. And the tenant says, well, I'm not going to be there. Well, it doesn't matter if you're going to be there or not. We need to get in and make that repairs, and then radio silence. That's not the tenant giving you permission. And that's not even 24-hour notice. You can't do it through an email or text unless they give you permission. Otherwise, it has to be a genuine written 24-hour notice that you post on the door. And I recommend that you take a picture of that posted on the door. Don't enter if you don't give proper 24-hour notice, or unless it's a genuine emergency, then you could enter, right? All right, these are legal protections for the owner. Paragraph 26, this is partial invalidity. Basically, I'll make this very short. This provision says, look, if the court determines that any other provisions in this lease are unenforceable, then the rest of the lease is still enforceable. It's called a severability clause. And basically, it makes sure that you can enforce the rest of your agreement. All right, 27, no waiver provision. Important provision, but it's got its limitations. This provision basically says if I accept rent as an owner, knowing that you've breached some covenant in the lease, my acceptance of the rent does not act as a waiver of that breach. And my word of caution to you on this is, just because this provision exists in there, don't develop a false sense of security. You could have a judge that says, yeah, I mean, for example, if you have a provision in there that says they can't have unregistered and untitled cars on the property, right? And you've been accepting rent for 10 years and there's been an unregistered pickup truck in your driveway. After 10 years, you don't try to evict the tenant because all of a sudden you want them to leave. Maybe the property falls under AB 1482, which was not in existence 10 years ago, so you didn't really care, but now you're under rent control and you're looking for a reason to terminate that tenancy. If if you've gone, some significant period of time ignoring a breach of the lease, and you're doing it with this sense that, hey, I have this non-waiver provision, don't rely on that. That may not necessarily save you in court. A judge could use their discretion to say, that's an unenforceable provision in your lease. Okay, paragraph 28, also important, attorney's fees. This caps your attorney's fees at $600, and it's a deliberate feature of the lease. It's strategically valuable to the landlords. Let's face it, most of the tenants, if are being evicted for non-payment of rent. If they had any money, in most cases, they wouldn't be being evicted. Most of your tenants don't have any significant assets. I'm not saying don't go after them for the money. I'm saying it's not like you're going to collect on them right now. But the key to this provision is by capping the fees at $600, you limit the incentive on the part of a tenant's rights attorney to really go conduct a jury trial. In other words, there are some leases that have what's called an uncapped attorney's fees provision. And I'm admittedly, I'm kind of shocked about that. I've written articles about it. I've told every landlord out there. That's one of the first things we check when a client opens a case with us. One of the first provisions we look at immediately is the attorney's fees provision to see if it's capped or not. If it's uncapped, we call our clients and we say, look, you have an uncapped attorney's fees provision. You are incentivizing the tenants' rights attorneys to go conduct a full-blown jury trial. You're motivating them to do that. Because if they win, they're going to file a motion for $50,000, $60,000 as attorney's fees because you have an uncapped provision. On the other hand, if you cap it first to $600, for example, there's really no motivation for them to go conduct a full jury trial because even if they win, the most they're getting out of it is $600. That's not a lot of motivation for a litigation attorney to go spend a week in court. That doesn't even include the preparation. So again, I'm going to caution everybody here, even if you've inherited a property or you bought a property that had existing leases, please go through every one of your leases right now and check your attorney's fees provision. If it is not capped, cap it with a 30-day change in terms of tenancy or eliminate it altogether. If it says prevailing party is entitled to reasonable attorney's fees, that's uncapped. Cap that right away. Now, there are a few jurisdictions like Pasadena. Doesn't matter if you don't, even if you try to cap it, they're going to say that unless the tenant signs off on that, that is an ineffective change in terms of tenancy. But it doesn't matter to me, in my opinion. Go ahead and change the terms anyway and cap it. Plant the seed in the tenant's head that you've just capped the attorney's fees on that. All right, paragraph 29, abandonment. Okay, so a word of caution on this. Some of you are going to hear what I'm about to say, and you're going to think that you can use this as an alternative to an eviction, and you cannot. Be careful with this. But what this basically says is if the rent is unpaid for 14 consecutive days, or it's delinquent for 14 days, then you can serve a notice of a belief of abandonment of real property. And if the tenant fails to reply to you within 18 days, then you don't have to go through an eviction. The property's yours. Now, the word of caution is use common sense and good faith in this. Don't use this as a way to get around an eviction, because if you do, and it's discovered later that, no, they didn't abandon the property and you knew it, then you would have a large lawsuit on your hands. So the way this works is, and it has happened, it happens more frequently than you might imagine. Tenants just disappear. They use midnight movers, they leave, you don't know what's going on. Nobody has seen them for 14 consecutive days. And what I would suggest you do is go over and serve a 24-hour notice to enter. Go in, check the property, see if if it's completely empty, then you don't have to go through an eviction. Go serve the notice of belief of abandoned real property, wait the 18 days, and once the 18 days passes, if the tenant has not responded to you, they have to do two things. They have to respond to you in writing saying that they have not abandoned and providing you with an address where you can serve them. If they fail to do that, then 18 days later, that property is yours. Now, the other word of caution is there's a notice of belief of abandoned real property and there's a notice of belief of abandoned personal property. You can have a situation where they left some stuff in the unit, they still abandoned. Do both notices. Do the belief of abandoned real property plus the belief of abandoned personal property. They're different notices, so make sure you understand the difference in them and how to fill them out correctly. and deal with both at the same time. All right, let's move on. Paragraph 30, credit reporting, disclosure, and authorization. California Civil Code 1785.26 requires landlords to notify the tenants that if they don't pay rent on time, you can report them to a credit bureau. Beyond the disclosure requirement, this provision also includes an active authorization for you to obtain credit reports for collection purposes down the line. So this is both during the tenancy and after the tenancy. So it's important. It allows you or a collection agency to run a credit on a former tenant without having to get their authorization down the line. So that's important. And the credit reporting laws have all been in flux over the last 2 to 3 years. I would encourage you, in fact, I intend to do an article on them to kind of clarify what they are, probably do a seminar on them as well. But before you start going down the Credit Reporting Act, what you can and cannot do, make sure you understand these laws pretty thoroughly. This is, unfortunately, we don't have time today to go through these, but we will do it at a future date. I'll talk a little bit more about your obligations to report credit in a minute as we get to the end, but for these purposes, this is basically you complying with your obligation to tell the tenant that, hey, if you don't pay rent on time, this could negatively impact you. All right, we're going to talk about, jump into some required disclosures. There's quite a few of them, actually. Let's start off with your lead paint warning. I won't spend a ton of time here, but any property built before 1978 may contain lead-based paint on it. There's a Residential Lead-Based Hazard Reduction Act, requires a disclosure for the pre-1978 housing. The penalties for non-compliance of this are severe. Roughly a $20,000 fine if you violate this law, but basically you have to, the tenants have a right to a 10-day inspection period before a lease execution is, that right to 10 days is required by federal law, and it can be waived in writing. And you should always provide the pamphlet. And I know that AOA provides that pamphlet for you guys. So I would always get a signed acknowledgement that you did that so the tenant can't come back later and try to claim that you didn't do it. But this is for pre-1978 buildings. Okay, 32. Lead paint knowledge statement. Unless otherwise indicated in writing, owner has no knowledge of lead-based paint. That's what this says. All right, so if you do have knowledge, you've got to warn them, but I know most owners have no knowledge of any lead-based paint, but this is the get out of jail free card on this one. The phrase, unless otherwise indicated in writing, basically preserves your ability to add a separate written disclosure of any known hazards that you might know about. The disclosure's got to be accurate, I will tell you that. An owner has had a lead test performed with positive results, can't use this provision to protect them. So it's not a workaround. If you do have a lead test that shows positive lead paint, disclose it. And that the disclosure of that is going to protect you. That's what this provision is basically designed to do. All right, military base ordinance disclosures. Most landlords in Southern California have no idea if they're, let me back up. As you guys know, since the late 80s, early 90s, a lot of bases and aerospace companies have shut down. There is a legal obligation for an owner to notify applicants and tenants if the property was within a certain location, within a mile of an ordinance, any sort of a base that had ordinance. And if you don't know what ordinance is, it's basically ammunition. So if you were within 1 mile of a base that had ordinance, you've got to disclose that. Most landlords' properties are not within 1 mile, but this is in there just in case. Most people are going to check does not exist on this box. All right, mold. Talk about that. Owner has, this is a disclosure that you've inspected the unit and you know of no damp materials or mold. Tenant accepts full responsibility for preventing mold through proper maintenance. The tenant has to immediately report any in writing, any leaks, excessive moisture, evidence of mold that can't be cleaned. This provision basically is protecting you by making the tenants liable for all the costs that you incur as a result of their failure to notify you of this. So Health and Safety Code, California Health and Safety Code defines visible mold as a substandard condition. What does that mean? If you have visible mold on your property, it's uninhabitable. Your inspection your inspection and the no known mold statement satisfies that pre-tenancy disclosure requirement. Basically, you're saying, hey, we're unaware of everything. We've inspected. We're unaware of anything that would imply any sort of mold here. And you have an obligation, Mr. Tenant, to tell us about it. And if you don't, if we incur damages, like let's say we have to tear out a wall, and this is a real case. I just terminated a tenancy maybe, I don't know, 6 months ago, based on this very scenario. The tenant failed to tell the landlord that she was there on her hamper, which was a wicker hamper. She was starting to see signs of what she didn't know, but she suspected, according to her, in a written text to the landlord, she didn't know, but she suspected it was mold. She didn't notify the landlord for months. Only at one point where she said, hey, I think this is growing. It's getting bigger and bigger. I think it might be mold. The landlord went in and did a test. And sure enough, it's visible mold that the tenant had known about for 6 months and hadn't said a word. The landlord used that as an opportunity to terminate that tenancy. But what she could have done, it required significant renovation. They did a test inside the wall, and the whole wall had to be torn out. The landlord had the right to go after her. If she would have let her stay in the unit, she had the right to go after her for all of those damages, because in her own text, she admitted that she failed to tell her about it. But in this case, like I said, instead, the owner just said, look, we're going to terminate your tenancy under a substantial remodel based on this disclosure. We're going to go through all the walls, do everybody's unit at the same time. But this is your protective measure. The tenant has an affirmative obligation to let you know about anything that looks like mold. And if they don't, they're going to be responsible for the damages. All right, let's talk about paragraph 35, additions and exceptions. So this is the part where you would start laying out I have a lot of clients that like to do their own rules. For example, parking rules pop up a lot. The parking rules that are in the lease are great, but they don't address every situation. I have clients that have student housing, and if you've ever had student housing, you know what students will do to your housing. So they have a whole separate sheet of rules. This is where you would write that out. We have a student housing addendum. We have a parking addendum in addition to what's in the lease, et cetera. That's what this provision is about. Section 36 addresses condominiums and tenant in common situations, and basically incorporates the CC&Rs or the TIC agreements into the lease, but you have to attach them. So this is where you'd say that CC&Rs, TIC agreements, included in the lease as an addendum or an exhibit, et cetera. But this gives you ability to customize this lease. I do encourage you, when you're renting a condo or any sort of a tenant in common unit, attach those CC&Rs or the tenant in common agreement as an exhibit. Make sure the tenant receives and signs for them at the move-in. Where you're dealing with a particularly restrictive HOA, it can cause problems for you. Review the rules with the tenant and have them sign off on them. Every page of the CC&Rs, give them a copy so that they understand they're on the hook. If you start getting fines because they're violating the HOA rules, that puts them on the hook for them. And it happens quite a bit. All right, we talked about 35 and 36, 37 notices, skipping ahead. All notices to the resident are served at the unit. Do not allow your tenant to say, hey, do you mind if I have you serve notices over here? It complicates evictions there, especially with some new service rules that are going to be coming into effect in 2027. I don't have time to go into those, but they're kind of burdensome for landlords. They're going to make service of any sort of notice or summons and complaint another issue that has to be litigated in court now. So don't allow your tenant to have you serve notices at any other place. This provision says no, all notices are served at your unit. All repair request notices to the owner must be in writing. They have to be delivered to the authorized person designated in the agreement. This can change, like I said earlier, so be careful. If you have, Mike Brennan Management Company, and then later you change to Jeff Fowler Management Company, you need to make sure that you've done a change in terms of tenancy. Otherwise, if they continue to notify Mike Brennan of problems, and then, Jeff is now managing the building, Jeff's not going to know to make any of those repairs, and you're setting yourself up for problems down the line.
Just real quick on that one, the AB 747, I know we don't need to get into it, but if they do have somebody other than the owner serving. And I don't know if the number's 7. I have to go back and look. But if someone other than the owner is serving, they do need to be licensed or have the
Right. They have
certification
to be a
to
registered
do
process
it.
server.
And
Yeah.
so they have to be a registered process server. That's the big thing that changes next year. So just for those of you that aren't doing it yourself, you're having your employee doing it. That's where you
Be-
really got to be careful. And
Yeah,
I'll
that's,
stop
you're
there
going
on
to
that.
run into problems.
Yeah.
There's a lot to that. Like I said, it goes into effect in 2027. It's going to make evictions and notices more complicated. And it's going to be just another hearing that the tenant can claim, I never got served, blah, blah, blah. There's new requirements. Even if you are a registered process server, there's new requirements for them. There's GPS coordinates that have to be documented. It's a lot. But we just don't have time to go into it now. The other aspect of this provision, though, that I don't want to skip over is California Civil Code Section 1962 has very specific requirements that have to be in the lease. And it's basically 3 categories. Who's the property manager? Who's the person authorized to receive service of process? Who's the person authorized to receive rent? And we run into problems with clients where it could have been years ago. Title changed. Let's say they owned it as husband and wife, and somebody persuaded them to put it into an LLC. So they drop it into an LLC and they fail to notify the tenant of that change. And then they want to evict the tenant for non-payment of rent. Can't do it. What 1962 says is anytime there's a change in management or title holder or ownership is the way they say it, you have to notify all of your tenants of those changes, or if you want, you will not be able to evict for non-payment of rent for any rent that accrued during that period that you did not comply with 1962. So it's another one of those provisions that has, not a lot of landlords understand how it works, and it has real serious ramifications down the line. So be careful with it. Understand it. It's Civil Code 1962 if you want to read it. It's convoluted the way it's written, but just remember this about it. This stuff has to be in the lease, and if it changes, title holder changes or management changes, you have to serve a new notice notifying all of your tenants about that in that building. All right, 38, inventory. This unit contains the following items for use by the resident, any furnishings, anything on the property. You have a shed, put the shed in there, describe the shed, take a picture of the shed. This section basically documents all of the items that you're furnishing with the unit and provides a checklist. So if you look at that checklist, it's important. There's a checkbox there, right, on paragraph 38. Says resident further acknowledges that the subject premises are furnished with the additional furnishings listed above and the attached inventory. So oftentimes, I don't know, I'd say maybe 60 to 70% of the leases I look at, there are check boxes in there that are not checked, and it will come back to bite you. So, I'll share with everybody on the call something that I learned when I first got out of law school. I really didn't want to practice law. I went to work for some of the major commercial real estate firms. One of those firms was Marcus and Millichap. And to their credit, they have an absolutely fantastic training program. And what they did with us new agents is they gave us a copy of a purchase and sale contract, and they said, go home tonight and read this entire contract line for line. Anything you do not understand, we want you to highlight and come back tomorrow, and we're going to explain it to you. So I encourage you to do the same thing here. Take this before you even have a vacancy. Take this contract plus the addenda that you use and go through and read every single paragraph and highlight anything you don't understand. And if you have a question, you can contact AOA or these slides. I already emailed them to Jeff. These slides are available. You can just request a copy of these slides. They're going to explain what the provision is. But more importantly, the point I want to make out of this is understand where the checkboxes are and why you need to check them if they're relevant. Because not checking them, which we're going to come to one that happens all the time that's really important, not checking them can turn around and bite you in the rear end. All right, so that's enough on 38 right now because, like I said, I'll come to one that's important that I'll use as an example. Let's go to 39. This provision basically says the tenant acknowledges receipt of the following documents. Okay. Again, just like the lease, I encourage you, print every single one of these out and read them with a ruler and understand what they mean. I don't have time today to go through every one of these. Jeff and I were talking about that. I'd be happy to, but we just don't have time. We'd be here all day long going through every single one of these. But you need to understand what these addenda are for. Some of these addenda are mandatory, okay? Just the bed bug addendum, you have to provide it. Information about bed bugs has to be provided. Pest control, EPA, those are all mandatory disclosures. Lead paint disclosure. Understand it, but the boxes next to them are designed to be checked off if you're including them. So it doesn't say that. It's not as clear as the other check boxes on here. But for example, if you're going to do a move-in inspection, check that box. The move-in inspection was included. It comes up in court, whether it's an eviction or a civil action, whether it's against you or against the tenants, where the tenants are invariably going to lie and say, oh, they never gave me that. They didn't give me the mailbox keys addendum. They didn't give me the remote control addendum. They never told me it was a smoke-free addendum building, you know? So the important thing to remember here is these are all of the addenda that are available. There's the e-bike addenda, you know, check the boxes. All right, enough on that. In paragraph 40 is basically a provision that says this is the entire agreement. There's nothing outside of this agreement. That's another reason why checking the boxes is important. If the tenant argues they never gave me that and it's not checked off in this box, they can argue that it's not part of the agreement. But more importantly, in paragraph 40 is it talks about joint and several liability. What does that mean? Let's say you rent to two different people and one of the tenants moves out and you don't know about it for a year. That other tenant is responsible for 100% of the rent. So is the tenant that moved out, especially if they didn't tell you about that. But both of them are responsible for 100% of the rent. Now, that doesn't mean you get 200% of your rent. What it means is that every tenant, no matter who's listed as the lessee, every one of them is responsible for 100% compliance with this rental agreement or this lease. Okay, so that's what joint and several liability means is I can go after tenant A for the entire amount, or I can go after tenant B for the entire amount, or tenant C for the entire amount. It doesn't matter. You're all responsible for the entire thing. Now, you can't double dip or collect more than you're allowed to. If they owe you $100 and you collect $100 from tenant A, tenant B and C are off the hook at that point. But tenant B and C still have to comply with the rest of the agreement, just like tenant A. All right, 41 is Megan's Law. I won't spend a lot of time here. This is basically a mandatory code section, a mandatory provision that you have to include that tells the tenants, hey, there's this website you can go to and check to see if your neighbors are on Megan's Law, sexual predator list, basically, sexual offender registry notice. You are not required to check to see if your neighbors are on there, nor do I encourage you to do that, because then you would have an obligation to tell your applicants that, hey, there's a sex offender who lives next door. But they have the right to do that, and this is basically giving them the website to go do it. All right, let's see. Paragraph 42 is receipt of agreement, language translation acknowledgement. So this, to summarize this paragraph, this basically says that the resident certifies they're fluent in English or have used their own adult translator during the negotiations and that they've read and understood the agreement. Why is that important? Because California has a law that says if the agreement is negotiated in a language other than English, they've got 6 major languages, Spanish, Korean, Chinese, Tagalog, I think it's called. I apologize if I mispronounce that. If the agreement is negotiated in that agreement primarily, then you have to have your lease translated into that language. Now, here's the interesting thing about that code section. It says that if the applicant brings their own adult translator and they translate, then you're absolved of those obligations to translate the lease and future documents. Okay, so that's what this provision does, is it basically says, hey, you're acknowledging, you're certifying that you're either fluent or English or you used your own translator to conduct these negotiations, and it gets you around that requirement of providing the lease in another language or notices in another language, like 3-day pay or quit notices. All right, did I skip one? No. 43, text and email as legal notices. Now, this one's kind of I don't want you to get a false sense of security here. This one basically allows you to say, hey, we agree that communication by text or email shall serve as legal notice in the following circumstances, okay? And it lists them out, and it gives the resident's text number and the resident's email address and the owner's text number. Again, here's my word of caution for this. If you start off with management company A and that changes, you've got to remember to change that. My other word of caution is tenants change their own numbers. Now, that goes back to the agreement that every year the tenant's going to update their personal information. You have the right to give them an application and have them updated. And then the last word of caution here is if you agree to this, you have to maintain it. All right. This is not an end all be all. You can't serve notices through text messages, like 24-hour notices, 3-day pay or quits. Those are not legally permissible to be served through emails or text messages. So like I said, don't get a false sense of security here. All right. 44, notice to residents of statewide rent control. Now, this is the paragraph I was referring to. You'll see here that there's a couple boxes. One says the property is exempt from statewide rent control. One says the property is subject to statewide rent control. I cannot tell you how many people fill these out, even experienced landlords, experienced real estate agents, and they never check the box exempt. And this is going to apply mostly in single-family residences. Well, if they don't check the box exempt, the property's not exempt. Okay, so it's subject to the statewide rent control. And when that happens, that's one of the other notices we check if you open a case with us. We're going to figure that out and notify you, hey, you didn't serve, this is not exempt. And where this commonly pops up is a single family home. You want to terminate that tenancy and you think they're not subject to the just cause requirements, but they are because you didn't check that box. So again, it doesn't matter if it's you, your children, a family member, your real estate agent, you need to double check this stuff and make sure if your property is exempt, check that box, because assuming it's gone month to month when you want to terminate that tenancy or do something else, I would tell you, hey, before we do anything, if you want to terminate your tenancy, their tenancy, do a 30-day change in terms of tenancy, notifying them that it's exempt. So in other words, it delays the process by not checking the box. It delays the process by about 6 weeks to 8 weeks. And it's going to be more costly for you because now you've got to pay to have this stuff served. So the word of caution is simple. If it's exempt, make sure you check the box exempt. All right, 45, positive rent reporting. This is the one I was talking about before. It's a brand new law. Very important that you understand this. If your property is, not all properties does the landlord have to offer the tenant the right to positively report the rental payments, or report positive rental payments, I should say. But in most cases they do. And there are some nuances to this positive rent reporting law. This started a couple years ago and it only applied to low-income housing, like Section 8, for example. Now the law just changed and went into effect. It applies to virtually most properties. And landlords have to offer their tenants the right to have their positive rent payments reported. And so if your property is exempt, again, here's a checkbox. You've got to check that box. If it's not exempt, you've got to understand this law. And again, this is just not the place that I have the time to go into the nuances of this law, but you have to do it. You have to offer that. Now, I've been saying this for years. I think it's a great idea because for the industry, because everybody knows that records are sealed, evictions are sealed unless a judgment's entered in a certain amount of time. This is a kind of a workaround for that. If an applicant just submits their application and they had great positive credit reporting for 3 years, and all of a sudden 6 months ago, that positive credit reporting disappeared, what do you think's happening? They're being evicted right now. So it is a great, I won't call it a way to circumvent, but it's a red flag in the application process. So I know it's kind of burdensome for landlords, but I actually think in the end, if viewed correctly, this could end up being a really positive thing for the industry. Again, I do want to caution you, this is the time to figure out the code sections. Let me give them to you. 1954.06, 1954.07. Understand both of those code sections, who they apply to, and how to comply with them. Okay, having said that, that is the last slide. That is the entire lease. We've gone through it. As you see on my last slide there, it says your lease is only as strong as your knowledge of what it says. That is the truth. If you don't know what your obligations are, you're probably not going to comply with them. That can get you in trouble. If you don't know what your rights are, you're missing opportunities to control that relationship. And in this day and age where we have nothing but rent control and just cause spreading throughout the state, knowing how to control that relationship is incredibly important. I find a lot of my clients get bullied, as just cause expands and tenants' rights expands. A lot of my clients feel overwhelmed. And the tenants certainly feel emboldened, and the tenants are engaging in behaviors, trying to basically bully the landlord into doing what they want them to do. And the reality is, AOA's got a super strong lease that protects you in a vast array of situations. And you don't have to allow that bullying. Yes, those laws are in place, but this lease addresses the vast majority of those laws and allows you to maintain control. But if you don't know what's in it, you're not going to have the ability to use it. So having said that, that concludes the webinar. I hope you guys will I hope it was beneficial for you. I'm happy to stay on for a little bit and take some questions.
Awesome. Mike, thank you so much for covering that. I just love how you do it. So
Thank
thanks
you.
again. And yeah, there are questions, and if we can, we'll just try to get through a few of them. Again, this is, if you're an AOA member, this is one of the questions that was in there. The lease agreement, it's part of your membership. So please use it and use the newest one whenever you can. All right. So first question here, is it best to put the name of the LLC as the lessor for protection?
I'm not entirely sure I understand what they mean by protection, but I like using the LLC. If you've got it in an LLC, yeah, use the LLC. Like I said, your management company can change. Your Whoever is managing it can change. You're not required to put it in the name of the LLC. It can be the owner or an agent, but it certainly makes the entire process, no matter what aspect of the process you're in, whether it's an eviction, doing the lease, anything like that, putting it in the name of the LLC is a good idea.
All right. And also, if you want to raise your hand, like there's the questions that are in the chat there, but if you raise your hand, we can take your question live too. And, I'll just ask you to unmute yourself, and then we can do it that way too.
And please, if you've got a specific city question, let me
Yeah.
know the number of units and the location of the property as well.
Yeah. And then also, like if there's the specific section, like section 1, section 5, whatever it
Right.
might be, if you mention
That would
that,
be
that can
helpful.
kind of help us get there too. All right. Second one, if we charge 25 extra for pet rent, should that be included in the rent amount in the first section?
That is a good question. Let me think through that. So you've got your base rent and you're charging $25 extra for pet rent. That's going to depend on whether you're in a rent controlled jurisdiction. Because if you are in a rent controlled jurisdiction, the first word of caution is understand what's the definition of rent in that jurisdiction. And most of them will define rent. There's pros and cons. If you included it right from the beginning as just base rent, then you could use that as the base rent when you're doing your rent increases. If you don't include it as base rent, let's say rent's 1,000 plus the pet rent's 25. When you go to do your rent increase, just make sure you're not including the pet rent. You're just going off the base rent because look, the pet could die, and if it does, you'd have to deduct that. So just make that distinction between base rent and pet rent.
All right. Is it good to have an 11-month term versus a 12-month? You said you like the month to month.
I know why they're asking
You
me. It's a
saying
good
that?
question. So most people are asking me that question because they're in a jurisdiction where the rent control or the just cause component doesn't go into effect until the tenants have been there for 12 months. That's AB 1482, the Tenant Protection Act, and some other jurisdictions.
And originally this was for Orange County. So I just want to just say this once for everybody. On the AOA form, when you log into your AOA account, you'll see the forms page. Then it says there's a bunch of groupings, and one of the groupings is specific cities and counties. Click on your city to see what, and that'll expand, and you'll see what additional forms are required in your city specifically. And there are, especially for Northern California, we have leases that are specific to Northern California for in multiple areas. Anyway, that just to say that, put that out there. All right, if we take over management, okay.
I actually I didn't answer that question yet.
Oh, I thought you did. I'm sorry.
So Orange County can have AB 1482. And so the question is it better to do 11-month leases? I think 11-month leases, it's pretty blatant what you're trying to do. You're trying to circumvent the rent control ordinance. I think if you want to do a shortened lease, I like that. I like as much control as I can get. Do a 9-month lease or a 6-month lease. Within 6 months, you're going to know whether that tenant is someone that's easy to get along with or if they're problematic. So if that's your goal to try to, be able to terminate that tenancy prior to a just cause ordinance kicking in, I wouldn't do 11 months. I would do 6 months or 9.
All right, if we take over management and the former management is listed as housing provider on the lease, do we need to do a change of terms to change that?
So again, a great question. You don't have to do a change of terms. You step into the shoes of that prior owner or manager. But what you do need to do is immediately do that 1962 letter I talked about. If you
Yeah.
don't notify all of the tenants of that change, like I said, you won't be able to evict for non-payment of rent. But you don't have to change the lease. If you want to, you could do a change in terms of tenancy. Hey, the lessor is now such and such. So, for example, in a situation that I could see that might be worthwhile is if the prior owner had a management company that signed on as the lessor, and then the prior owner sold that property, and now you're going in there, you could do a change in terms of tenancy that says, hey, it's now owned by Rose Apartments LLC, whatever it is, and now
Mhm.
they're the lessor. Sure, you could do that. If you have to do an eviction, though, be sure to attach that change in terms because that's now part of the operative lease document.
Yeah, and we have a specific form called change in management and or ownership. So that form they should use whenever that changes. Okay, tenant had a breach of a 1-year lease after serving a 3-day notice to quit, left with unpaid rent of April, also left the property with damages and dirty. Does it automatically allow me to use the security deposit for April unpaid rent? Will also take them to small claims for the breach and leaving the property with damages.
So the short answer to that, if I understood this correctly, assuming I did, the short answer is yes. You can immediately use the security deposit for that unpaid rent for April. And there's a specific order that most landlords will use when doing the security deposit accounting. They'll do unpaid rent first, damages second, then cleaning third, and then missing personal property like remote controls, keys, stuff like that. So yes, it does allow you to immediately go after that. One thing I didn't raise that this lease actually gives you the right to do is it does state that if you're in a 1-year lease, for example, and the tenant terminates that lease early, the tenant's on the hook for the entire balance of that 1-year lease until you lease it up to the next tenant. And so if you go 3 or 4 months, and I encourage this, if you use high FICO scores, stuff like that to get a good tenant, you go 3 or 4 months, the tenant is still on the hook for those 3 or 4 months, and that's in the lease. That's a protection that's built into it. You do have a duty to mitigate your damages by leasing as reasonably quickly as you can. But that's a situation where, let's say let's say they left and it was clean, but there was no damage, but they owed you rent and it took you, 3 months. You could use the security deposit depending on the timing, when they vacated, when you do the deposit accounting, what rent has accrued at that point. You could use the security deposit for 2 months worth of rent if you had 2 months on hand. So yes, it does allow you to immediately make that rent due and owing and deductible out under the security deposit.
All right, how much time do you have?
I have time for a few more.
Okay, we'll take a few more. Here we go. Old 2019 lease in a single family home, non-RSO, JCO, so this must be City of LA. House with the 1-year leases going month to month beginning July 1st. There was never a TPA exemption issued. Is posting the exemption of the property on July sufficient, or is personal service required?
I'm not sure I'm not sure I understand the question. So I've
So
got a
they
single family
didn't, there was
home,
no, like in the 2019 lease, there
right?
wasn't, there's
That I
no
get,
non-exempt.
but
So
what
do
kind of
they,
notice are they trying to post? Let me answer what I think is an appropriate answer to the question. If I got it wrong, I apologize. But if you're asking whether you should serve the exemption notice now, absolutely. Do it as a change in terms of tenancy and get that implemented right now. So 30 days down the line, if you want to terminate that tenancy, you can.
yeah, so
Now,
just, So
I'm sorry, go
serve
ahead.
the notice, was what you're saying. Serve the notice, don't do anything else. Serve the notice, wait 30 days at least, and then do
That's
it.
right. And then if that was the question, if that's what it was geared at, should I serve the exemption notice now? Yes. And
Mhm.
then do it as a change in terms of tenancy. Let the 30 days run. It would be 35 days if you mailed it. Just do it for 45 days in advance. This way you can't go wrong. And then 45 days later, the property's exempt.
All right, and we're gonna just, they asked more than one question, but we're just gonna keep going just because there's more questions and everybody will try to just give them one. Okay, what about tenants that have plants with mold? How do we handle that?
Okay, so if the I, I guess you can have plants with mold. My first question would be, are they indoor or outdoor plants? Not that it's terribly relevant. Either way, it's visible signs of mold, and they should be notified that they're creating and or maintaining a health and safety hazard on the property. Before you launch that missile, though, I would encourage you to take pictures of that, document that, so when you do launch the missile, you can come back and verify that it's been taken care of. But two, if they claim that it never existed, it's just a pretext to evict them, you've got the pictures to prove it. But I mean, certainly if they're indoor, yeah, those have to go immediately. If they're outdoor, there's ways to dry out soil so that it's not conducive to mildew or mold or fungus.
Yeah, that could be unhealthy plants too.
Yeah.
You know. All right. If a tenant moves out and does not provide forwarding information for their new address to the landlord, is it landlord's responsibility to email, text, or call them to get their new address, or is it their responsibility so that the landlord then issues their security deposit and any refund to the last legal known address?
Yeah,
Like,
that's the obligation is merely to the last legal known address. If they don't provide you with that information, to the best of my knowledge, you have no obligation to determine that. Now, the caveat to that would be if you enter into a lease and it's got a provision in there that says, hey, you guys are going to email each other, and that's fine for the return of the security deposit, and the tenant does not provide you a forwarding address, because you have their email address, I would say, yeah, go ahead and reach out and email them and say, hey, where do you want this sent? And send it wherever they ask you to send it, but keep it in writing so you have a documented paper trail. This is where they told me to send it, and that's what I did.
okay, here's one with section 7 about the occupants. It in there it says that the resident shall pay an additional rent of 100 per month for the additional occupant. I think that's just LA County where that in the RSO or LA City RSO where that's even possible. Can you even charge for additional occupants outside of when they
I
take
would
on a
flip it
new?
over and say it slightly differently. I would say that unless it's prohibited by a local jurisdiction,
Okay, yeah,
then you
there's
can do it. And you are right. The city of LA specifically lays that out in their RSO that, hey, if they have an additional occupant, you can charge them, as long as it's in the lease, you can charge them, blah, blah, blah. But I would, again, I'm unaware of any law, especially in the state of California, that prohibits that.
okay.
So I would say unless it's prohibited by a local jurisdiction, you can do it.
Okay. A question for you. Do you do LLCs for people? Do you put those together for people?
I do not. I would talk to your CPA about how to do that. There are tax ramifications for the way those are structured, and you want it structured correctly. So I would go to your CPA.
Okay. There's so many questions, we're not going to get through it all.
Let's do three more.
Yeah, okay. Can I require my tenant to sign a new lease if I already sent them an addendum to their current lease and that they haven't signed yet?
Can I require my tenants to sign a new lease if I've already sent them an addendum that they haven't yet signed? Okay, so I have no idea what jurisdiction this property's in. Let's assume it's in Orange County because we're doing an Orange County seminar. So let's assume it's in a non-rent control or just cause jurisdiction somewhere in Orange County. You can require them if it's not subject to a local jurisdiction, like rent control or just cause, then let's assume it's under the Tenant Protection Act. And the Tenant Protection Act specifically states that you have the right to require the tenants to sign a lease with substantially similar terms. And if they don't do that, that's the basis for a termination of a tenancy. So what you can do is, if you want to, if that's the direction you want to go, you want to push them into a new lease rather than that addendum you've already given them. What I would suggest you do is rescind the addendum. Send them some sort of a communication that says, hey, I'm rescinding the addendum. I'm not asking you to sign the addendum. I'm asking you to sign a new lease. And here's the lease. And if you're under the Tenant Protection Act, that, like I said, that would be, if they refuse, that's the basis of a termination of tenancy.
Great. Okay. Regarding guest staying consecutive days, how many days should you require the guest to not be present before starting the next 10 consecutive days?
Well, it says consecutive. I mean, it's not a quite, not sure I understand the question. How many days should we require? Theoretically, if they're not there for one day, then that starts the process
Yeah,
over.
actually, yeah, ours says 10 cumulative days.
So if it's cumulative, there is no
In a month.
period of time that they have to not be there. You could do it if they do it 10 cumulative days in I think it's a 6-month period.
6 month, yeah, that's right.
Then you can employ that provision. If it's said consecutive, because I know some leases do say consecutive, and some local jurisdictions actually have the word consecutive. It's a requirement in order for a landlord to terminate a tenancy based on that. So be aware of your local jurisdiction as well. But if it says cumulative, then there is no period of time they have to be gone. It's either 10 in a row or 10 over a month or 10 over a year. It doesn't matter. I'm sorry, 10 over 6 months. It does matter. It'd be a 6-month period.
Yeah, we had a couple questions about this, so I'll ask this one. If our lease says tenant agrees to pay landlord for all attorney's fees incurred by landlord, does that go both ways? Meaning,
Yes.
is uncapped, or will you put a cap?
Absolutely, it goes both ways. So California, it's interesting the way they did this. There's actually case law that says if you have a one-way provision for attorney's fees in a contract, it's actually a two-way. It's a mutual provision. So yes, if you have that lease, whoever's asking that question, I would cap my attorney's fees right away because that's exposing you to liability.
Okay, and then can I restrict the possession of keys to the named tenants in the lease? The context is the tenant made
Yes.
a boyfriend a key.
Yeah, absolutely. You can do that. I'm not entirely sure how you enforce that. How do you prove that they gave the boyfriend a key, especially when the boyfriend's going to come in and say they didn't give me a key? And the tenant's going to lie and say I never gave them a key. But yes, it should be in the lease. Because you never know. You could get a text message from the boyfriend that says, hey, Jamie gave me the key, but my key's not working for some reason. That would give you the right to say, hey, no, you've got to give me that key. And that the key, but you can, to answer the question, you can limit the keys only to the named lessees. Absolutely. It's a safety function.
So, we do lots of live streams and seminars and things, and attorneys don't always agree on everything. I've had one attorney specifically emphatically say it needs to be a dollar amount when it comes to the 6%. That late fee amount, it needs to be a dollar amount. It cannot be 6%. You can't just put the 6% there. So what would you want you to respond to that as we
My
wrap up?
response, it is true. Attorneys have different interpretations and both can be reasonable. It just depends on what you're comfortable with. And I'm familiar with that argument. In fact, there's a line of thought out there that says not only does it have to be a specific dollar amount, but it has to be a specific dollar amount based on a daily amount of damages. And I disagree. Show me, like I said, that there's a Supreme Court of California case that specifically states that 6% is a reasonable late fee. The problem is rent changes all the time. So if you put a specific dollar amount in there, you're limited to that even after you've done rent increases. If the Supreme Court says 6% is a reasonable amount, then my opinion is you put the 6%, and as rent increases over a decade, let's say, that 6% amount goes up. What is important here is that you're not just making up numbers, right? You've got to the point it's not even really a late fee. Late fees are considered punitive and they're technically illegal in a residential lease. What it really is, if you want to get very technical about it, is what we call a liquidated damages provision. And what it means is that, look, if you're late on your rent, I incur certain costs. I, as the landlord, incur certain costs and fees and stuff like that. And it costs me money. And so I'm going to, we don't know what that amount is. It's hard to determine exactly what that amount is. So you and I are going to negotiate this amount, and we're going to agree that 6% of the rent is a reasonable amount, a reasonable estimate of the amount that I'm going to incur if you're late on the rent. And like I said, the California Supreme Court said 6% was reasonable. So in my opinion, 6% is fine to write in there. That way it allows it to go up. There's inflation, it adjusts for all of these things. I'm very familiar with that line of thinking that says an amount, and that amount should be based on the daily rental amount. And it should be spelled out in the lease. And like I said, whatever you're more comfortable with. Here's my counsel, I'll say. Regardless of which way you decide to do it. The key here is if you ever have to do an eviction for non-payment of rent, what you're trying to avoid is that the court looks at the late fees that the tenant paid over the years and says, hey, this was an illegal late fee provision. So all those fees they paid were illegal. And so you technically owed them a credit. And so your 3-day pay or quit is overstated because they didn't really owe you all that amount. You owed them some money. That's what you're trying to avoid. So regardless of which way you decide to go on this, if you go to do an eviction for non-payment of rent and you want to be ultra conservative, what you'll do is back all those late fees out of the balance before you serve the 3-day pay or quit. Right? Then there's no harm, no foul either way. The other word of caution onto what I just said is be careful, because there are some jurisdictions that have minimum thresholds for the amount of rent that's due before you can serve the 3-day pay or quit. So if you're going to back those late fees out, make sure they don't drop you below the minimum threshold, because that would make your notice defective as well.
Great, thank you so much. And for everybody, if you want to see more of Mike Brennan, then come out tomorrow to San Gabriel. On Wednesday, we'll be there, and we have a seminar again. If you're a member, it's free. It's free for members. This specific live stream, it'll be out on YouTube just for a little bit, but we're going to bring it into the AOA membership program, because really, like, this doesn't benefit you. He worked line by line through the AOA lease. If you're not a member and you don't have access to the lease, then it's really not of any benefit. So this will be in the membership program. Some of the stuff we make it easy for you to view as a member, but then we also want to bring it inside the program, just because there are certain things that are for members and people that are paying the membership dues and everything. So thank you for that. And anything last parting thought there from you?
No, I just think I want to thank the people who attended. I think it's important, like I said, to understand exactly, these are legal documents. They establish your rights and obligations. So it's important that you understand what's in them.
And if you're on Zoom, you may not be able to see the slide, but so his number, it's 855-285-2230. That's 855-285-2230.
Yeah, we're happy to send you the slides.
Yeah, and we have them too. So just
Right.
send it to membership@aoausa.com, and then we'll shoot those back to you.
Thank
All
you,
right,
Jeff.
thanks, everybody. See you
All right.
tomorrow.
Bye.